T start in the two interrelated read petitions between the same parties, the employee Santosh Chandrakant Poddar and the employer Bajaj Auto Limited. Justice Amit Borkar at the Bombay High Court has delivered the common order pronounced at Mumbai on April 30, 2026 para. The petitioner workman had challenged the award of January 18, 2026 passed by the Industrial Court Thane via the complaint filed by him insofar as the tribunal had declined the relief of reinstatement with full back wages. On the other hand, the employer filed a writ petition assailing the very same award to the extent the industrial court had recorded the finding that the termination of workman had taken place during the pendency of reference and therefore amounted to breach of section 33 subsection 2b of the Industrial Disputes Act 1947. A charge sheet was issued to the workman on October 12, 2012, alleging misconduct. Understanding the order number 31 applicable to the establishment, the charges were thus founded on alleged acts of misconduct recognized under the service conditions governing the parties. A domestic inquiry was initiated against the petitioner workman. Upon conclusion of the proceedings, the inquiry officer submitted his report with final findings on July 31, 2014, holding the petitioner guilty of charges leveled against him. After receipt of copy of the said report, the petitioner had submitted a letter of apology on or about October 16, 2014. The recognized union had also requested for sympathetic view. By a separate letter, the union had requested the management to extend to the petitioner, as was allegedly extended to 13 similarly situated workmen para. It is the further case on record that an industrial dispute was then pending between the respondent company and Vishwa Kalyan Kamgar Sanghatan, the recognized union para. During the subsistence of such dispute, the respondent company and Sanghatan entered into a memo of understanding on August 14, 2014, pursuant to negotiations concerning suspension of 18 workmen whose enquiries were pending para. Under the said memorandum, it was agreed that 13 out of the 18 workmen would be taken back in service subject to acceptance of charges, submission of written apology, undertaking for good conduct and compliance with the terms of settlement para. It was also agreed that selection of those 13 workmen would remain within discretion of the management, whereas the disciplinary proceedings against the remaining 5 workmen would continue. The petitioner was one amongst those 5 workmen whose inquiry was not brought to an end para. Thereafter, after considering the letter of apology, the respondent company has stated to have examined the past service record of the petitioner and formed an opinion that neither the apology nor the union's request deserved acceptance. Consequently, the management reached the decision that the petitioner ought to have been dismissed from the service. The petitioner came to be terminated from employment on October 17, 2014.